Funding for Idaho Reports is provided by the Friends of 4, 10, and 12, the Corporation for Public Broadcasting, and by a grant from the Laura Moore Cunningham Foundation.
Who wins and who loses from the Swan Falls Compromise? That's our story tonight. Good evening. It has been a week and a half now since the governor, the attorney general, and Idaho Power Company announced their compromise settlement of the Swan Falls water rights issue. It's been just about enough time now for all of the interested parties to really wade into that agreement and start asking lots of questions. Questions, for example, about how much the agreement will cost the ratepayers of the Idaho Power Company system. Questions about how the proposals will be implemented across southern Idaho. Questions about the real impact on future agricultural development. Questions essentially about who wins and who loses as a result of this compromise. There are all complicated questions, and there are many different and sometimes contradictory answers to the questions. Tonight, with the help of two of Idaho's most knowledgeable water law attorneys, we'll try to explore some of the issues and answers surrounding the Swan Falls Compromise. Before we start that, though, a quick recap of some of the principal proposals contained in the compromise. Perhaps the most important element is a minimum stream flow just downstream from Swan Falls Dam. The proposal calls for a minimum summer flow of 3,900 cubic feet per second, a minimum winter flow of 5,600 CFS. The proposal calls for restrictions on new upstream storage projects and the establishment of a public interest criteria that would be used to determine where, when, and who would be allowed to develop new irrigation projects. Producer Bruce Reichert has some additional background now about the winners and the losers.
The Snake River is the lifeblood of farmers and irrigators. It is also the reason our electric power bills have remained so low. But there's a trade-off there, a political trade-off. As farmers and irrigators pull more water out of the river, that means there is less and less water for hydropower needs. And by now, almost everybody realizes that the days of free and unlimited water are gone. A compromise that was to be the blueprint for Idaho's water policy on the Snake River was hammered out this summer behind closed doors by the governor, the attorney general, and Idaho Power. But that compromise has raised many questions, not the least of which is who won and who lost.
I don't really think there are any clear winners and losers. The idea of the compromise was to avoid that situation, to avoid either a clear, overwhelming victory for the state or for the utility. So I think basically if there's a clear winner or loser in the compromise, we probably didn't do it right.
And does Idaho Power have any idea what this compromise will cost its ratepayers?
No, because of the difficulty in the assumptions. We've kicked it around in trying to decide if we could arrive at it, and we can't come to a meaningful assumption to give the power production people to put in their models to come to a study.
And yet you were able to come up with figures for those television ads that you ran this summer.
Those weren't our numbers. The company has never had a number.
But a former legislator says it's easy to tell who the winners are and who the losers are.
Winners were a few people who will be developing desert land and receiving a very large subsidy from almost everyone else to develop it. The losers were all of the consumers of electricity in Idaho, including the farm and the residential and business consumers. So nearly everyone lost and a relatively few people won.
And is he surprised that Idaho Power has no figures?
I think that there are figures, and I'm not surprised that some of the parties to the agreement aren't willing to admit that there's a huge increase in electric rates coming down for consumers, but in fact the Hamilton-Lyman study, which is the most definitive study that was done for the legislature, shows that with a river flow reduction of 1/3 of what this agreement provides, the rates would go up $52 million a year to the consumers. And of course, with a 3 times that amount of river flow reduction, you have to assume that the rate increase is going to be quite a bit more than $52 million a year.
You've used a figure of $150 million. Can you justify that?
Well, yes, there is a potential for an increase of as much as $150 million, because Hamilton and Lyman, in their projection of 52 million, based it on a reduction of river flow of 171 cubic feet per second. This agreement provides for a reduction of 600 cubic feet per second.
Well, that is a lot of money. I've seen that same number, but I think he has taken one study and multiplied it by 3 to come to 150 million. Other people have looked at that same study and said that a comparable figure would be 6 million.
But Robison says the compromise could result in a 30% increase for ratepayers.
It's a huge subsidy. It's a huge giveaway of an existing energy resource that the people have paid for. It was the consumers that paid for the dams and generators on the Snake River. It wasn't Idaho Power that paid for them. And the effect of this agreement is the same as dynamiting some of those dams and taking away the power generation.
So how do the governor's people justify their position?
I think it's better than anyone's worst-case scenario, but at the same time, everyone has had to give a little.
One of the worst-case scenarios has the ratepayers paying $150 million. Is this a viable figure?
Well, I think I can give you several reasons that it's probably an extreme case, and there are several mitigating factors that I don't think will let this come to pass. First of all, I believe those numbers come from the Hamilton-Lyman study, which say that there will be a $52 million impact from the development of 195,000 additional acres. Well, first of all, $12.6 million of that figure would be impacts on ratepayers in Oregon and Washington. And for the state of Idaho, perhaps we would want to exclude that to bring that $52 million figure down to $39.6 million. But there are several other reasons that this won't necessarily come to pass, at least not very quickly at all. First of all, there are several public interest criteria which will be implemented as part of this Swan Falls resolution package. And you have to look at this as a package, and no particular item can be taken by itself without including the impacts of the other pieces of the package. One of these public interest criterion is that there'll be a limit of 20,000 acres per year.
These comments were echoed by another economist, this one with the Public Utilities Commission.
The whole thing hinges on what will be the actual agricultural development which will occur over the next 20 years. The more agricultural development there is, the more water's taken out of the river, the less hydro power production we would have.
The whole compromise seems to hinge on what the farmers and irrigators are going to do.
Yes, I agree with that. And the farmers and irrigators are driven by what market conditions are. And to get back to your first question, which was who are the winners and the losers, that in large part is going to be dependent on what the world agricultural market is. And that's something that is very difficult to ascertain or guess or whatever.
Isn't the bottom line that ratepayers are ultimately going to be paying more to subsidize irrigators?
I think to the extent that agriculture will be developed and the settlement has 20,000 acres, I think that it's reasonable to assume that there will be some rate increase.
But according to Robison, the ratepayers have never been asked if they're willing to pick up the tab.
I think that traditionally there's been an idea in Idaho and southern Idaho that you ought to irrigate more land, and I think a lot of people accept that, but the consumers have not been told by the governor or the attorney general and others that they are going to pay a huge increase in power rates for this development. They've never been asked that question. Are you willing to pay a lot higher electric rates so a few hundred people can irrigate some more land? I believe if the consumers were asked that question, then they would give the answer and we would not have this agreement.
If you focus on what it looks like was given away, I think you miss the point. What is retained, I think, is more important than what appears to have been given away. Without this shift in state policy, there was no end to it. 3,300 maybe if the state could stop development quickly enough to get to 3,300 and no further down. This way, you not only stop the slide at 3,900, but you make new development go through public interest criteria, and I think that's a major step for protection of the ratepayer. Without that, if the power company lost the case, Katie barred the door.
For more analysis now of our basic question tonight, essentially who wins and who loses from this compromise, we turn to two attorneys who by any measure must be considered among the most knowledgeable people in Idaho on water issues. Ray Rigby joins us tonight in Pocatello. Mr. Rigby is an attorney from Rexburg, a former state senator. He chaired the governor's task force on Swan Falls and has represented Upper Snake River water users on Swan Falls water matters. Scott Reed is with us tonight in Moscow. Mr. Reed is an attorney in Coeur d'Alene, as a leading Idaho conservationist and a former member of the State Water Resource Board. Mr. Rigby in Pocatello, let me begin with you. Just in general terms, is this a good compromise?
I think under all of the circumstances it probably is. I would like to suggest that in light of the discussion that we've already heard, maybe an appropriate statement would be one made by Chief Justice of the United States Supreme Court one time when he said a page of history is worth volumes of logic. And I would like to start by saying that according to the figures we've been given by the Idaho Power Company itself, 0.5% of its power revenues are derived from the Swan Falls project. Over 80%, some have said as high as 85%, of its power generation comes from the 3-dam Hells Canyon complex. All of us know that the Hells Canyon dams have been subordinated. And when the PUC made the study on the revenue that may be lost and would have to be made up, they were considering that if the water got to Swan Falls, then it gets to the Hells Canyon complex. And so in effect, they have gone around the subordination provisions in the Hells Canyon licenses. Now, that's a factor that I haven't heard in all the ads that have been coming over television and radio in the last several months, but it's a factor that's real. Now, couple that with a little more history. Mr. Roach was testifying before the Federal Power Commission in Washington in 1953, and this issue was very much alive because the public wanted the High Hells Canyon Dam.
He's a former Idaho Power Company official.
He was the former president of the Idaho Power Company. And Jordan was the governor of Idaho, and he was very concerned about the same things that we're talking about tonight. And he was asked by a federal power commissioner, Mr. Roach was, what about, has your company adopted a policy for the integration or joint use of the water for irrigation and hydro? And this was his answer. For a period of over 37 years or more, the company has had a very firm and fixed policy of complete coordination of the use of the Snake River, always placing the use of that water for irrigation in a prior position to the use of the water for hydroelectric development. And currently, all of our state permits in the state of Idaho carry in them a specific provision which preserves for irrigation not only now, but at all times in the future, a prior claim on the water.
So I don't want to interrupt you, but I think what I'm hearing you say is that all things considered, and giving the history that you've just given, the power company, and I assume its ratepayers, did pretty well by this deal.
As a matter of fact, they were given a site of the greatest hydroelectric facility in the United States in exchange for a license that had the subordination provisions in it. And even the Idaho Supreme Court said they agreed to it.
So
there should be no question now.
So in effect, they've gotten back some of the things they gave away in the 1950s. In your
Well,
opinion.
as a matter of fact, I'll say they have.
Okay.
Because before the Supreme Court decision in Idaho, they operated under the supposition that everything upstream was subordinated to power use. Matter of fact, the commissioner again asked them, he said, is that a part of your application for these licenses on Hells Canyon dams? And they said yes. And the commissioner said, make sure that's a part of the record. And there followed a license. Now, I know the...
Let me just interrupt for a minute and get Scott Reed into this. I want to get his assessment right off the bat as to how equitable and fair you think this deal is. You heard Mr. Rigby's analysis.
Mark, let me give you my 1984 scorecard. And I've done some thinking about who won and who lost, the precise question you're asking. And there's several in each category. Idaho Power very clearly won. Tom Nelson and the others who negotiated for Idaho Power did, I think, an outstanding and brilliant job on behalf of their people. They got rid of an enormous exposure in dollars that could have occurred if the lawsuit had proceeded along the lines that it originally commenced. I think there's 7,500 farmers down there whose water rights were under a cloud, first by the decision and then ultimately by the lawsuit that Idaho Power started. Those people are going to be clear winners. There are going to be 125 new farmers. That's how many people are out there on that 80,000 acres according to Water Resource Board estimates. I think the politicians who participated, the governor and the attorney general, are winners, and those who were involved in the bitter controversy are winners in that they have got it behind them, or they're trying to get it behind them. It won't plague them as it might continue to do if we're not resolved. The losers are the ratepayers. Ken has given you some figures from the Hamilton-Lyman study. That Hamilton-Lyman study was an absolutely thorough and exhaustive, and I must say, to my viewpoint, a little bit confusing study, and I don't come up with the same numbers he did, but there isn't any question that a diminishment of the flow is going to cost the ratepayers a substantial amount. I've come up with some figures, one of which came from Idaho Power sometime long time back, which was that for every new farm that is going to be put in with water that's taken out of that river, it's going to be a $100,000 annual subsidy. I've done some calculations on the Hamilton-Lyman figures, and I come up with a $200,000 annual subsidy for each one of those farms. And the real losers, and the ones who don't even get to be counted in this, are the fish, the anadromous fish downstream, because you're taking away 600 CFS of water and putting it further diversion out of there at a time when everything that we know said we must put more water into the river, not less.
Well, let me just clean up Mr. Rigby's initial point, and then we'll move back to some of yours. So you would agree with him, I take it, that the power company has won something that maybe they weren't entitled to win?
The lawsuit, as it was started, and it started in the Public Utilities Commission with a theory that Matt Mullaney came up with, that Idaho Power had abandoned its water rights, and therefore it should be assessed with the costs of what it had lost. And it also was saying that you must stop further development at this point. Those are two prongs of the lawsuit. Idaho Power was not happy with the adjudication by the Public Utilities Commission, so they filed the suit in the state court and went up to the Supreme Court. But they definitely have eliminated an enormous risk, and any time you're in a lawsuit where the prayer for damages, shall we say, is as big as they were talking about, what they've come up with is a very, very good settlement from their point of view.
Mr. Rigby, let me go back to you and pick up on Scott Reed, a couple of points that he made there. He clearly sees the winners and losers, I think, differently than you might. Am I correct?
Well, not really. I think his analysis was quite correct. The only thing is we have to evaluate this thing in terms of the constitutional and statutory provisions and what we've operated under for many years. Just to give you two more points of history, which I think are critical to this, go to the Constitution itself. And in Section 3 of Article 15, it says the right to divert and appropriate the waters of the streams, I'm paraphrasing, shall never be denied to its citizens, except that the state may regulate and limit the use thereof for power purposes. Then it goes on to say that as between the users, priority is first to domestic and then it's to agricultural. And so what I'm trying to convey to the people of this state is the idea that we've operated for a long time under a system where we all assumed that the power generation was not equal in right to an agricultural use, and that it could be limited and restricted. And so we've always done that. As a matter of fact, in this very Swan Falls project in 1972, we passed an act while I was there, where we're going to have a joint project with Idaho Power on the Swan Falls Guffey project. And they required, and we consented because we believed it, that this provision be placed in the statute, and it's still on the books today.
So in a way, we've gotten back to where we were before the celebrated Swan Falls
That's
case.
my point. All we have ever asked, and I think it's so important to consider this, all we've ever asked by the subordination provision is that we put everybody back where we thought we were before the Supreme Court decision.
Mr. Reed, how about that? Is Mr. Rigby right?
Well, I don't think there's any question it's a big backward step. However, I think you have to look at where we are now.
Well, I agree with that. I'm not saying, all I want to say, Scott, is that we in southern Idaho have been depicted in the ads and in the publications and so on as people wanting to take something from the power company for nothing. And they say that's unfair. And all I'm trying to tell you is that even the power company president, even their own attorney, in an opinion given to the power company, said that they would have difficulties on this issue because of the doctrine of estoppel.
Well, it's a complicated lawsuit, and
Right.
I have always advocated that those people who are already developing should have their rights protected because they have already developed and they relied upon what was in place. What I'm suggesting is that actions such as the Water Board and then the legislature adopting a minimum flow at Swan Falls, the action of the federal government in giving up a new High Hells Canyon Dam are both instances in which we now are recognizing as public bodies that there are higher and more important uses for the water that include leaving it in the river. And those times have changed from the time when the highest, best, and major use of water was to put it out upon the land.
Well, I think that's the real issue. In other words, today, all these lawsuits and all this negotiation involves two important things. One, vested water rights, and who has them? And two, a policy that this state ought to adopt one way or another. And these things you said are very important bearing upon that issue. But for instance, when Ken Robinson talks about 52 million loss, does it mean that they should be able to go around the subrogation provisions in the Hells Canyon licenses? And if they don't, they're going to lose 52 million, therefore we took it from them? And when Mr. Reading talks about the study he made, we asked them specifically, isn't this study based on what would be lost at Hells Canyon, which is already subordinated? And they said yes.
But does it make sense to have the ratepayers pay for 125 new farms? Because that's all we're talking about.
Well, really, now let me give you what I think are some more concerns besides that.
Well, let me just interrupt
all right.
to ask if that is, are we really talking about that few farms?
Let me use the figure, because it's 80,000 acres, and in the Water Board study that was put out at the time of the following the Hells Canyon, the Swan Falls decision, they used an average of 643 acres, which is somewhere in the ballpark of the general size of a farm that you have to have in order to make a living.
All right. Let me tell you now what I think is got to be considered when you talk about that subject. This says, in effect, 600 CFS out of the river at Swan Falls. What I'm suggesting is, what if somebody drills a well out in West Jefferson County and takes water from the underground aquifer? How much does that affect the flow of the river at Swan Falls? Now, we know if you take a CFS of water out of the reservoir, it's a CFS. But how much water is it taking out of that flow if we take it in a pump out of a deep well in West Jefferson County? So what I'm saying is two things. First of all, maybe we shouldn't even be administering groundwater in the same connotation under the same law as we do the surface water. Maybe they ought to be exempt.
That is one of the questions.
We don't have these facts and figures yet, right, Scott?
No, I think we do, because the information that we have on the Snake River aquifer, though we don't have all of it, is that is water that goes in upstream and comes out down below. When we started talking about lowering the pump values as part of the water plan, the fish farming interests at Thousand Springs were just up in arms about the fact that you're going to have a reduction in water.
Mr. Rigby?
All right. Senator Jordan used to give a beautiful explanation of this. He said, supposing we had had the Idaho Power Company file on the full amount of the water in the Snake River at Hells Canyon before there had been any upstream rights. The policy of this state would have been all the water must flow down the river to go through those generators in a non-consumptive manner and on out the state. He said a better method and a better policy would be use it. Use it over and over and over again as it went down the state through the river. Now, what I'm saying to you is we don't talk enough about recharge of the river. Isn't it interesting that
Excuse me, by recharge you mean water that comes in someplace,
Right.
is used someplace, runs back into the river and is counted, as it were, down the stream?
Absolutely, because it's measured wherever the appropriator takes it out of the stream. And for instance, in this proposal, they talk about zero flow at Milner, and yet 3,300 or 3,900 at the Murphy site. Where does that come from?
Just
That's
below Swan
recharge.
Falls. Okay.
So that's why it's so important that we consider that upstream storage, that we consider the recharge of that river. And so when you talk, and then one other point I want to make that hasn't been talked about is they assume that if you turn this thing loose, 80,000 acres of land are going into production next year. And that just isn't so, and it wasn't happening at the time of the lawsuit.
The figure says 20,000 acres per year or 80,000 acres in any 4-year period. I think Ray's come up with something new, and if he manages to get it technologically advanced, perhaps it'll all come true. If you can actually grow dehydrated potatoes without using water at all, then we will have a total recharge of the river, but
Well,
water's being used.
We won't give that idea up either, because there are some great technological developments. But I am saying that there's no proof, Scott, and I defy anybody to show it to me, that how much water that deep well in West Jefferson County is taking from the flow of the stream, the Snake River, at Swan Falls. We know it affects it, yes, but is it a teacup, a gallon, 1,000 gallons, or what?
Let me just interrupt here because we have such a short amount of time left. Mr. Rigby, you obviously disagree with Ken Robison, who said earlier the big cost would be to the ratepayers. There will be some cost to the ratepayers any way you figure this, right?
Well, let's put it this way. We had nobody alarmed at the time of the lawsuit about how much land was being developed. Sure, there was some talk about it, but no great alarm. Now, a lot of things are happening, aren't they? For instance, the Northwest Power Planning Act says that now the power companies should buy some of the power from these small projects. I can tell you there's 6 of those small projects in my office right now to use non-consumptive water to go through little plants, and the power companies buy their power, and maybe we won't need all that power. You see what I mean?
I hear what you're saying. Scott Reed, how about that point?
Let me pick up the Northwest Power Planning Act, because that act also says that Idaho must provide an additional amount of water that is going to come downstream in order to meet the program they have to restore the anadromous fish. When Ken Dunn testified before the commission, he said Idaho hasn't got any water to give. Well, here we are. We've taken 600,000, we're going to take it out of the river, and we're still saying, no, we haven't got any water to give. The demands are there in the Planning Act that says you must provide more water, and we must provide it. We should be putting it in the river, not taking it out.
Okay. Well, gentlemen, I'm not surprised, Scott Reed in Moscow and Ray Rigby in Pocatello, that you've helped us raise more questions perhaps than we've answered here tonight. But it's
we haven't even touched the subject yet.
Right.
good of you to join us. We appreciate it. That's our time for tonight. We'll be back tomorrow. I'm Mark Johnson. Good night.
Funding for Idaho Reports is provided by the Friends of 4, 10, and 12, the Corporation for Public Broadcasting, and by a grant from the Laura Moore Cunningham Foundation.